Ralph Carnovale-Carr, you were convicted by a unanimous jury verdict of 1 charge of sexual assault and 2 charges of rape. The circumstances of the offending, in summary, are these. At the time of the offending, you were 63 years of age. You managed and own a management company for the entertainment and sporting industry. At the time of the offending, the victim was aged 27 years of age. The offences were committed in March 2023. In these reasons for sentence, I will refer to the victim by anonymising her name by the use of a pseudonym as is appropriate. I will refer to her as Sally. In 2021, through a then friend, she learned that you were well known in the entertainment and high-performance sports industry, and that from time to time you required a personal assistant. The victim's friend had gone on to secure such a position with you, but the victim remained very interested in that position for herself. She was studying to be a physiotherapist and was interested to enhance her curriculum vitae with experience in the fields that you were concerned with and with the people whom you managed. In July 2021, she sent you an email expressing interest in the position. Again in October 2022, she emailed you acknowledging that her friend was in the position that she was expressing interests about, and for you to keep her in mind in any position if it became available in the future. Sometime after becoming aware her friend was no longer working for you, she again asked you if you still needed a personal assistant. You replied to the effect that you were always, quote, looking for good people, end quote. You were overseas at the time, and you indicated that upon your return you would arrange a meeting. The jury heard evidence from the complainant that in August 2022 you emailed her and suggested a meeting. An interview was arranged at your office in Lennox Street in Richmond. At that meeting, you discussed with Sally some projects, including an autobiography and a film script. Sally was interested by these projects and the prospect of working with you at close quarters with your clients and yourself. She said it sounded, quote, really interesting and fun. You told her she was successful in her application and you invited her to your home in West Melbourne for drinks and with some of your friends. That evening you sent an Uber to pick up Sally and to bring her to your residence. There she met you and a friend of yours, Alfredo. That evening 3 of you listened to music and used cocaine. Late into the evening, in the early hours of the 24th, after Alfredo had left, leaving you and Sally alone, the jury heard evidence from the complainant that you sat next to her physically close and that you tried to kiss her. You were both affected by alcohol consumed. Sally pushed you away while you made fun of the situation, and when she resisted, you desisted. She said to you, quote, if I let you do this, if I let you fuck me, you will never respect me as your employee, end quote. You agreed with her. She reiterated that a sexual role was not what she was interested in. She asserted to you she was not sexually attracted to you and said words to the effect, I'll never want to have sex with you, the sooner you understand this the better. You told her you were in a relationship in any event. That evening Sally and you got into your bed and went to sleep. She had drunk a lot of wine and used cocaine. She said she felt you had stopped being pushy and you were, quote, going to be chill, end quote. In the bed, however, she said she again told you to go to sleep after you tried to grab her. You were in the bed and she was on top of the bed, and then later she too went under the covers. Both of you then went to sleep after she rebuffed you a number of times. The following morning you had to leave, and when you went to kiss her goodbye, she again refused. The jury heard this evidence and another episode I'll come to in a moment as an uncharged act in order to place the later offending in its proper background and context, and to suggest that the later offending had not occurred totally out of the blue. The jury were directed about the proper use of that evidence in their considerations. Sally then began working as your personal assistant. She described working for you as really fun. She interpreted what had occurred the night I had just described as an aberration about which you were embarrassed. There were many occasions and events when, having worked out of the West Melbourne address as an office, she then stayed a few times there overnight, and she considered that part of her work. On those occasions she slept in a spare room. She said she stayed there because it was more fun to hang around with Ralph. There were no more sexual advances by you. On an occasion in November 2022, you had invited Sally over to your house to meet a friend of yours called Skills for drinks. Later that evening, she stayed in a spare room at your residence. The next morning, she found you in another spare room watching TV. She sat on the edge of the bed and then laid down facing the TV on top of the covers. While in that position, you still being in bed watching TV under the covers, you put your hand on the back of her leg. She felt that touch was inappropriate, and she gave evidence that again she rebuffed you. You then did it again, and she yelled at you, and you stopped. This was the second uncharged act heard by the jury, led by the prosecution with the same purpose I've highlighted above. The victim later in evidence told the jury she had dealt with these acts firmly and had got on with the social and working relationship with you without much ado. I should add that I do not consider these acts instances of aggravation of your offending. They do, however, highlight the fact that you could not have been in any doubt as to her wishes clearly expressed to you in relation to sexual activity or conduct from you, and form part of an important aspect of an understanding of the relationship which existed between you and Sally at the time and at the time of the later offending, which go to elucidate the kind of breach of trust and moral culpability which were involved in your conduct at the time of the offending. The evening of the event just described in the spare room at your home, Sally and a friend of hers met you and Skills for dinner at St Kilda, pursuant to arrangements which had been agreed before you left your residence that morning. You left dinner before everyone else, and Sally and your friend continued, and her friend continued with Skills and later on with Alfredo. During this later time and in your absence, there were some unpleasant exchanges between Sally and your friends. The next morning she sent you a text message apologising for her own behaviour and expressing her wish not to continue in her employment, in which she described an environment including the use of alcohol and drug in which she was not comfortable remaining. She, in effect, concluded her employment with you on that occasion. Your response was that you would see her the following week back at work. You did not speak to her again till March of 2023. During that 5-month period, Sally did not work for you or your company. She did not respond to text messages from you, but could not log out of some of your corporate social media accounts. On the 14th of March 2023, as a result of a query about an entry on Facebook which had tagged you, as a courtesy to you, she sent you an email about that and suggested that your staff remove all previous employees from social media to prevent further unwanted incidents. You thanked her and told her in reply that you missed her being around and in effect proposed she assist you with the book you had mentioned to her earlier. You wrote, quote, "It's an exciting project and I'd love to work with you again," end quote. Sally replied she was happy to meet you and discuss time requirements and contractual arrangements and remuneration. Ultimately, you agreed to meet on the 23rd of March. On the afternoon of that day, Sally told you that she was planning to visit her mother in Bendigo and came to see you on the way. She was riding a bicycle and met you at the West Melbourne address to discuss going back to work for you, depending on the hours required. At that time, she was contemplating doing a PhD at Melbourne University. You had a meeting with Sally and afterwards had a couple of drinks. You told her you were going to a friend's place to watch the football and she asked if she could come along. Sally, still intending to see her mother, left that evening with you. Going to her mother, she said, was a flexible arrangement. Sally said she decided to stay because, quote, it was more fun hanging out with Ralph, end quote. Sally said it was her idea to have a drink at your place before leaving. After that, you left together to go to your friend's house, Mr. Gucciardo. Sally said that she had a fair bit to drink at your home before leaving. She recalls 1 bottle of wine being consumed as well as use of cocaine. After that, she had a shower and changed clothes and felt fine before leaving. You drove and Sally was with you. The two of you, Mr. Gucciardo and his partner, watched the football and then you went back to your house. Wine was consumed while watching the football. She felt intoxicated. Before getting to Mr. Gucciardo's place, you and Sally had a conversation about boundaries that had arisen because she said you had propositioned her again and she indicated in no uncertain terms that she was not interested in that. Sally said to you, I don't want to have a romantic anything, and you said to her, don't rule it out. She replied, if you try to do and bring it up again, I'm going to shut you down, end quote. She said, I wouldn't have been able to trust him, referring to you, if he wasn't going to respect that particular boundary that I'd been establishing, end quote. She gave evidence that at Gucciardo's house you were getting angry or frustrated about something on the television and she reached over and tried to settle you down by touching your leg and calm you down. She kept her hand there. She recalls it concerning the referendum which was discussed in that period. She said she felt that it was her role to do that because she was the one who wanted to hang out, drink and do drugs, and she almost felt responsible because of how you were acting, which she described as loaded. She felt she had encouraged the drinking and she felt responsible. I note Gucciardo and Keogh gave evidence about this matter and gave their evidence in marked contrast to Sally's about your demeanour, while, however, agreeing that at one point Sally put her hand on your thigh. He said it was a laid-back atmosphere, said Mr. Gucciardo. You were not drunk, he asserted, and had not drunk much at his place, and that you were not agitated or angry. Miss Keogh agreed with that evidence and said she saw Sally put her hand on your thigh. You then left with Sally back to your place. You both went into your bedroom, which had a bed and a sofa in it. You went onto the bed and Sally sat on the couch. She was upset about her boyfriend and her father. She was talking to you about these things and others, and she was crying. You got up off the bed, went over to her and hugged her. You then pulled her onto the bed and you were comforting her. You hugged her and patting her head, you said, quote, I won't let anything happen to you, end quote. She felt drunk. You tried to kiss her. You tried to kiss her shoulder and arm. She said, quote, you need to stop, I don't want this, end quote. Why are you doing that, she said. You said to her, you're just so sexy. She said, quote, are you crazy? Can you not, like, I'm not okay with this. You were saying, I'm not going to be able to sleep. You need to let me have sex with you. She was pleading with you and trying to reason with you. You touched her leg, her bottom, her waist, her chest, and between her legs. This was charge 1. You were moving away. She grabbed the pillow and was crying into it. She was lying, she said, on her side stomach, and you put your hand down the back of her pants, shook your hand around, and put a finger or fingers into her vagina. Charge 2 of rape. She said that lasted not long. She didn't say anything. She said nothing was working. You weren't stopping. She felt you move her pants down over her butt cheeks and penetrate her vagina with your penis. Charge 3. You were behind her. She said you put it in once and pulled it out and then put it in a second time. It was each time a second in duration. She turned, got up and punched you on the face. At that point, you grabbed her, your nose and face, and you were on your knees at the end of the bed. She yelled at you, quote, "You're a fucking rapist." You said, "No, I'm not. I just put my fingers." And she said, "No, it wasn't. I know it was your dick." She was angry. She said she couldn't make sense of the fact that you could not understand. She was saying no. She said she was stupefied in disbelief. You were still clothed, and so was she. She went into a spare room to calm herself down and collect her thoughts. She said she wanted to resolve the situation and talk to you. After some time, she found you in the bed in the other spare room. She said to you, quote, "That was really bad, what you did," and that you said to her, "Sorry." She said it's okay, but then you pulled back the doona and she saw you were masturbating your penis, and you said, "You have to do this." She said, "No, this guy is fucked." This was 40 minutes to an hour after the rape. She said she didn't know what to do and was in shock. At some point, she started to write out what happened before she came to see you. She said she remained in the house there because if she left, she would have to accept the fact she was a rape victim now, and she didn't want to be that. She didn't want to be that reality. She communicated with her mother by way of messages and complained of the rape, which the jury saw and read. Later that morning, she spoke to police after initially being reticent about contacting them. In evidence, she said that she really wanted to learn from you and that in your life you'd done some amazing things, that you treated her like an equal, and she really appreciated the opportunity to work with you and emphasised and empathised with you. She said, rhetorically, "How can you trust someone to console you in that way? That means a lot to you, but then have that happened." Quote, "He told me he would always be there for me, and then he did what he did. It was," quote, "feeling like actually not really mattering." End quote. I consider that the objective gravity of the offending is very serious. The offending was not premeditated or planned, and as I've indicated, the earlier uncharged acts may be able to be used as placing the offending in a more complete context and background, but not by way of propensity, but as examples of some conduct which meant that the offending was primarily to be assessed not out of the blue in terms of credibility or plausibility. The sexualised conduct inherent in those two occasions are incidents which in very general terms indicate the kind of relationship which the victim wished to pursue and which you, by and large, had adhered to until the offences were committed. They are not matters of aggravation, I repeat, nor do they lend themselves to conclude that your offending was premeditated rather than spontaneous. Despite that consideration, your conduct was appalling. There was no threat of greater violence, any weapon, any injury caused, no further humiliating act or degrading conduct, and the acts themselves were on any view of very short duration. However, rape is a crime of violence. This was committed by you in an egregious breach of trust and predatory opportunistic upon a young woman who admired and had reposed a significant amount of trust in you as an employer and as a friend. Although Sally demonstrated a significant degree of self-confidence, drive and ambition, you took advantage of her at a point in time when she was not only intoxicated but vulnerable and in need of comfort, at a point at which she looked to you for care and support. It was at that point, instead, you chose to abuse that trust in the most abhorrent manner. She had repeatedly asserted by warnings and protests that sexualised behaviour was unacceptable to her, and despite that, you did not desist. You did not desist either after the digital penetration or after the first penile penetration. These were acts which infringed fundamental rights of bodily integrity and safety, which disregarded for your own sexual pleasure. They inevitably damage to the victim concerned and the community who is perturbed and repulsed by such violation. These offences strike at the most basic values, the norms of a decent society. In my view, you were a man of significant age, experienced in managing persons in the limelight in various fields, most likely with notable egos, people who required able and confident management. This was an environment which you must have understood the victim to require mentoring and supervisory protection, professionally and personally, that an experienced employer should have provided. It is in this context that your age difference is relevant, and the breach of trust involved is to be assessed as grave. Despite the brief duration of the physical violation, the circumstances of your offending, in my view, place the objective gravity of the offending in the mid-range of seriousness because of these circumstances. Although no victim impact statement has been prepared by the victim, the court can draw reasonable inferences from the fact that your acts have had a profound emotional, psychological and physical impact upon Sally. These consequences are not momentary and are conversely long-lasting, often impacting on all aspects of a person's life, from self-esteem to vocation to relationships and to health outcomes. I take these impacts into account. Excuse me. Denunciation and general deterrence are significant considerations in this case, as they are in every case of rape. But the sentence of the court must deter other persons who may be like-minded to ignore issues of consent and agreement to sexual conduct. I note for the record that yours was not a defence of consent, but that practically all salient aspects of the victim's account were fabrications and lies, including the sexual assaults and rape. Such deterrence aims to vindicate the social values of the community and the safety of its citizens, and to extend protection by just punishment to those who conduct themselves in such selfish and callous manner. The specific circumstances pertaining to this case, in my view, also require that a measure of general deterrence is applicable because of the way in which your conduct was directed to an employee and a young assistant. The message which the court sent to would-be rapists is unequivocal: to dissuade those who plan or act on the spur of the moment. The sentence must aim to discourage potential offenders by the serious consequences of such behaviour. I accept, as I shall explain in a moment, that your career in the field in which you prospered may be at an end, so the aspect of specific deterrence of the sentence is much reduced as far as elimination. The consequences, as you will experience them by extracorporeal punishment in particular, and the circumstances of your imprisonment, favour this view that this sentencing principle has no role to play in this sentence. The offence of rape carries a maximum penalty of 25 years imprisonment and 10 years for sexual assault. The maximum penalties are not a determinative factor in my sentence, nor is the maximum penalty the starting point of my sentencing view. The maximum penalty is one factor of a range of factors that Parliament has prescribed that I must have regard to, see Section 5, subsection 2 of the Sentencing Act. Both offences may be committed in a wide spectrum of severity and circumstances. The offence of rape is a Category 1 offence pursuant to Section 3, subsection 1 of the Sentencing Act 1991. Pursuant to Section 5(2) capital G, the Court must sentence the offender to an order under Division 2, Part 3 of the Act, namely a custodial order. It was conceded by the defence that a head sentence and non-parole period disposition is to be ordered in this case. Pursuant to Section 5, subsection 2(a)(b) of the Act, the Court must have regard to the standard sentence for rape, which is 10 years. The standard sentence is a legislative guidepost. While these provisions do not affect the instinctive synthesis approach to sentencing, It is not a mandatory or minimum sentence. It simply operates within the regular sentencing principles which are applied to the sentence. Section 11, capital A, subsection 4 of the Act requires the court to fix a non-parole period of at least 60% of the head sentence, unless it's in the interests of justice not to do so. You've been convicted of 3 sexual offences. Each of the offences is a sexual offence for the purposes of Part 2A of the Act. As of Charge 3, you will fall to be sentenced as a serious sexual offender. This will be entered in the court's record. Accordingly, I determine the length of any sentence on Charge 3 by having regard to protection of the community as the principal purpose for which the sentence is imposed, and you may order a longer sentence than that which is proportionate to the gravity of the offence, considered in the light of its objective seriousness. I note the prosecution did not seek a disproportionate sentence, and I do not intend to impose such a sentence. Further, I do not find that you currently pose a risk to the community. Additionally, every term of imprisonment imposed on these charges must, unless otherwise directed, be served cumulatively. Although the provisions of the Sexual Offender Registration Act are applicable, they are discretionary in the circumstances here. Prosecution did not make application for you to be declared a registrable offender. You were convicted of these offences following a criminal trial where you pleaded not guilty. You are not to be punished for your plea of not guilty. However, this means you are not entitled to any discount for pleading guilty. You maintain your innocence of these offences, and consequently there is no evidence of your remorse or contrition to reduce your sentence. In sentencing you, I take into account your background and personal circumstances. You are 66 years of age. You were born in Melbourne of Italian parents who both came to Australia when very young. Your father died in December 2025, and he began work as a boilermaker, ultimately managing a plumbing firm. Your mother is 87 years old, and she is a cancer patient currently with attendant health issues. You have 2 sisters, one of whom is a carer for your mother, living with her. You have an older brother. You completed Year 12 at school, and you have worked since age 13 or 14 while still at school. You have an excellent work history in this period, from factory work to supermarket employment. After leaving school, you worked for an insurance company for some 18 months. Your interest in music went beyond playing music to the music industry itself. You set up RCM Management to manage musicians and bands. You ran that company for 35 years before your reclusion. As part of the management role, you also represented people with sporting careers. You married twice. The first lasted some 3 years, and there are no children of that union. You had 3 children from the second marriage, which lasted 16 years. You have ongoing excellent relationship with your second wife and the 3 children who are aged 18, 15 and 10 years of age. You have no prior criminal history, and since these offences you're not committed other offences. Evidence of your otherwise good character is an important sentencing factor which the court is bound to consider. I have received a number of character references on your plea. These references, which I've carefully read, some 14 of them, come from people who have known you for many years, either as family members or in a professional capacity. They speak of a man who is respectful and considerate in all his dealings. Your cousin, Mr. Scaramuzzino, who is an executive of a large post-secondary education organisation, writes your offending is out of character, and that in the business world you are well known and highly regarded. His mother, your aunt, writes of your kind, sensitive and generous nature. She expressed astonishment at your offending. Mr. Di Battista, a friend of some 20 years, and Kate Nielsen, a former employee, both write of your courtesy, politeness and generosity with your offending being entirely at odds with the man that they know. Your older sister and younger sister both write of your compassion, humility and honesty. They describe you as devoted to your family, your support for charitable concerns, strong in your religious faith, and a loyal, dependable person. They write of your devotion particularly to your family and children, and of the difficulty of separation, especially from your mother and children. Your mother wrote of the difficulty of separation from you during a difficult period of health and the loving, caring and compassionate son she knows. Mr. Faraci, who has recently worked with you, Miss Driessen, whom you managed in the 90s, wrote of your reliable, honest and professional qualities. Your cousin Rose says your offending is totally out of character for the caring man she has known all her life. Mr. Batista notes your willingness to assist others. Miss Safiro Lunde, your cousin, consider you a guidance, protector and hard-working, known for generosity and kindness, who created employment and mentored young people. Mr. Kavanagh, a friend of some 30 years involved in the arts, music and horse racing industry, writes of you as an adoring father, creative and inspirational, professionally and personally. Like you, he's an Australia Day ambassador. One particular reference from an immediate family member was particularly touching, dignified and descriptive of the impact of your incarceration upon your family. This letter described in a very measured and balanced way the significant impact which unfortunately will impact on your family in the period of time to come. These references are not challenged or contradicted by the prosecution, and I'm satisfied on their evidence before me that you are a person of otherwise good character. I sentence you on the basis that this offending is isolated instances. I make substantial allowance for this aspect of your life. I take into account that there has been significant delay in these proceedings which affect the sentence. There are two limbs to the issue of delay, and here it is the first unfairness limb which was relied upon. The chronology in this matter is relevant, with the offending dated March 2023 and this sentence occurring today, the 20th of August 2026. The matter proceeded relatively regularly through the court system to committal in June 2024. Thereafter, a number of significant delays led to some recording of evidence in July 2025, pre-trial arguments in October 25 and December 2025, and trial in July 2026. None of these delays were due to your conduct in the proceedings, and I accept that during this period you experienced significant distress, noted consistently by your treating psychiatrist, Dr. Rakov, as contained in her notes for this period. The pending and unresolved nature of these serious charges over this period and this impact I will take into account. The references which I've mentioned give rise to considerations which pertain to the impact on your family, particularly your mother and your children. This is a matter which will render your imprisonment more burdensome. This is a matter which is enlivened in relation to each sentence of imprisonment as a natural consequence of this separation. It is obviously a burden upon a man who enters custody for the first time at your age and state. Although this aspect may raise arguments about the basis for its consideration, in my view it is simply a relevant factor in determining a just sentence in all the circumstances by reference to an aspect as may impact on the sentence upon you. The circumstances here are not exceptional in relation to that separation from your family, but it is appropriate in my view to take this aspect into consideration, even if only on the basis of a merciful consideration. I make some allowance for this consideration, particularly given the ages of your family members concerned. The positive aspects of your personal circumstances I have noted, and support in the community which you enjoy mean that your prospects of rehabilitation are very good, and that the risk of reoffending is, I accept, practically eliminated by these proceedings and this sentence.
Can you hear it?
Can you just, could you just close that link, please, Mr. Zanin? Can we do something about that, please? Thank you. Much of the plea hearing was concerned with your mental state since being charged, and more particularly about the period since you went into custody after the jury verdict. Even as of this morning, other material has been made available to the court, partly in relation to that and partly in relation to concerns about your health. It was submitted that the two limbs of the Queen and Verdon's Principles 2007 VSCA 102 were enlivened. The fifth limb posits that mental impairment is relevant to sentencing in that it could increase the hardship experienced by an offender in prison if they suffered from mental impairment at the time of sentencing. The sixth limb posits that mental impairment could justify a lesser sentence where there was a serious risk that imprisonment could have a significant adverse effect on the offender's mental health. It was said in your case that your mental health, as described by Dr. Rakov, a psychiatrist, fit into these two aspects, and that allowance should be made to decrease your sentence. Dr. Rakov produced a number of reports apart from her notes of her consultations from November 2023 to August 2026. The notes from November 2024, as well as a report dated the 30th of June 2026, report your response to your situation. This period relates to your concerns primarily over legal proceedings and with the reputational damage of publicity and disclosure of your identity. I note that the first suppression order application was in November of 2023 and then proceeded step by step towards October 24 and December 24. You were and have been prescribed the medication. As of June 2026, Dr. Rakov opined that you were at substantially elevated risk of psychological deterioration, self-harm and suicide because of the prospect of public identification and the criminal proceedings. The opinion was that you're experiencing a clinically significant impairment, with clinical risk factors identified in that report. In that report, the single greatest factor likely to exacerbate your risk would be public identification through media reporting. That eventuality materialised shortly after verdict, when the suppression order was lifted. Of the critical risks, I am satisfied that neither self-harm or suicide have materialised in any sensible fashion in the last 28 days of imprisonment. I accept on the evidence of Dr. Rakov given before me that there has been some elevated risk of psychological deterioration. This has related primarily to the conditions under which you've been detained, that is, effectively in solitary confinement, 23-hour lockdown since your remand before sentence. I accept that Dr. Rakov has diagnosed continued post-traumatic stress disorder, the recurrent major depressive disorder and generalised anxiety disorder with panic symptoms and agoraphobia. In the report of 14th of August 2026, she found you to have been more subdued and experiencing further deterioration, particularly in the regime of incarceration to which you've been subjected. Despite this rigorous regime, she did not characterise your suicide risk as imminent. She opined that despite some delays in the early period of imprisonment, your condition can be treated in custody, as well as your physical health conditions, particularly high blood pressure and other significant problems. That view was confirmed this morning when I viewed the Justice Health material which was tendered to the court. She could not assert that continued imprisonment would cause irreversible psychiatric injury, but current conditions of detention could aggravate symptoms of post-traumatic stress disorder, depression and anxiety, making recovery more difficult and prolonged. It goes without saying that treatment of mental health issues is probably better managed in the community, but that is not the reality which you now face. The court must have confidence that correctional authorities will provide conditions of reclusion and provisions of adequate and appropriate mental and physical health to each prisoner. That, of course, includes classifying you as soon as practicable out of solitary lockdown conditions and continuing to provide adequate medication and assistance. The evidence this morning from Ms. Bridget to this court satisfies me that within a very short period of time after sentence, you will probably be reclassified to a place which has already been determined and to a lower classification, enabling you to have proper access to light, to other services, to other prisoners and to other prison staff. I take therefore into account both limbs mentioned of Verdon's considerations being enlivened. Facing a period of incarceration at your age is a difficult predicament for you. I take into account these considerations in assessing the quality of your time in custody. I have taken also into consideration that your custody so far has been in conditions which are severe and hopefully to be limited forthwith. 23-hour lockdown with limited or no association with other prisoners, with little or no access to natural light or fresh air, limited contact with staff and reduced privileges, in my view, should be used in very exceptional cases. The application of Verdon's limbs will reduce your sentence. This case has generated an unusual amount of publicity, mostly adverse to you. I accept that your professional life and significant aspects of your attendant personal circumstances were constructed around networking connections and contacts developed over many years in a challenging and competitive environment where relationships and reputation are fundamental. I accept that this outcome may mark the effective end of a future resumption of activities for you in that field. It was submitted that this was now practically impossible and that your past career was at an end. This represents extracural punishment. The extent to which this factor, as well as public opprobrium, should be taken into account by way of mitigation is not settled. See DPP and PAL 2019 VCC 260, judgment of His Honour then Chief Judge Kidd. Enfield and the Queen 2010 200 Australian Criminal Reports 1, Queen and Dunn 2003 VSCA 150, and Ryan and the Queen 2001 206 Commonwealth Law Reports 267. I am of the view that because of the length of your involvement and the nature of your role in your employment, this aspect is more pronounced and apparent in your case than in most other cases. I have made an allowance in the sentence for this matter. In a similar vein, the recording and broadcasting of my sentencing remark is merely considered to be an effort to demonstrate the nature of open justice, making the work of the court accessible to the community. I've considered the matter of totality in order to arrive at a sentence that deals appropriately and proportionately with the whole of your offending. Any orders for cumulation, in my view, must be moderated to the appropriate extent to this principle. This principle continues to apply in relation to the sentence I impose on charge 3, because when you are sentenced as a serious sexual offender, the presumption of concurrency is reversed, section 6 capital E of the Act. I will make the sentence on charge 3 the base sentence. This is the most serious offence. Charge 2 forms part of the same episode, and therefore it is my view that there should be a significant concurrency as between the charges. However, some modicum of cumulation is appropriate in recognition of separate and distinct criminality in the conduct, which is sufficiently serious to warrant it, in particularly the first rape subject to count 2. In sentencing you, I am also required to have regard to current sentencing principles. The prosecution provided the court with some relatively recent cases on standard sentence cases, which have involved the charge of rape as one of the charges dealt with. I was assisted by the approach taken by the court in these matters, and note that each case must reflect the particular circumstances of the case. Current sentencing practices are but one factor to be considered and are not the controlling factor of the sentence I must impose. Individualised justice demands that I endeavour to balance competing considerations to reach a just and appropriate penalty in the circumstances of your case. On charge 1 of sexual assault, you're convicted and sentenced to 1 year imprisonment. On charge 2 of rape, you're convicted and sentenced to 5 years imprisonment. On charge 3 of rape, the base sentence, you're convicted and sentenced to 5 years imprisonment. I order that 9 months on charge 2, 3 months on charge 1 be served cumulative on charge 3, making a total effective sentence of 6 years. I order a non-parole period of 4 years. Your release on parole will be a matter for the parole board. I declare that you've served 28 days, excluding today, by way of pre-sentence detention, and I will have that entered into the records of the court, as will the fact that I have sentenced you on count 3 as a serious sexual offender. I make no order as the Sexual Offenders Registration Act. Are there any other ancillary orders? Thank you. I'll just pause for a couple of minutes. I'll stand down before my ruling on the stay application. The defence has applied to the court for a stay on the sentence imposed upon you on the basis of the provisions of section 309 of the Criminal Procedure Act. That section provides that a sentence is not stayed during the appeal period unless an order is made under subsection 2, which in turn provides that a trial judge may stay a sentence if satisfied that it is in the interests of justice to do so. It was said in a flourish of advocacy that anyone who had seen and heard the complainant give evidence in this case would be very concerned about the verdict, and if not, would have lost sight of justice in this matter. I wish to firmly reiterate that having seen and heard the complainant, I have not lost sight of the justice of this matter. It was practically suggested that this jury verdict should have elicited the fevered response of that great judge, Justice Stark, in Ryan and Attorney General 1967, Victorian Reports 517, who was confronted with the issue of stay, which was in effect a stay of execution, a reprieve from the death sentence for Mr. Ryan. That indeed was a life and death situation in which His Honour said, quote, "There is no time, and in the circumstances one must not make a mistake." He acceded to the application with the memorable line, quote, "Finality is a good thing, but justice is better." As it turned out, the report notes that Ryan met his finality only 4 days later, despite His Honour's order of a stay. In that judgment, His Honour noted that clearly the power to stay could only be exercised sparingly and on clear material. His Honour also noted that the court should intervene if it, quote, senses that there is a real possibility of a miscarriage of justice, end quote, with reference to Lord Atkin in a 1933 English decision. I have no such sense in this case. The defence placed significant reliance on Mr. Justice Crouch's ruling in Grant and Sadiq 2016 VSC 662. I shall return to this case in a moment. Before doing so, I wish to set out some principles which are crucial to this application. There is no more quintessential judicial act than a conviction of a criminal offence, a first step towards and a necessary prerequisite for punishment, which may include loss of liberty. This purely judicial act is performed by the arm of the court charged with deciding the guilt of the accused, that is, the jury. The jury is the body entrusted with the primary responsibility for determining guilt or innocence. A jury bringing together the experience and common sense of 12 thoughtful and diligent members of the community will ordinarily be best placed to assess whether the evidence is so improbable as to raise a reasonable doubt of proof of guilt and it will be an unusual case when an appellate court is justified in intervening on this basis. The High Court decision in Pell makes clear that an appellate court undertaking this kind of inquiry must start from the assumption that the jury regarded the complainant's evidence as both credible and reliable. The defence in this case has carefully laid out 17 or so matters which render the complainant's evidence incredible or glaringly improbable, if not outright fabrication and lies. It is said the evidence is so incapable of being accepted that it must bear adversely on the credibility or reliability of the complainant's evidence as a whole. If the jury had a doubt about a part of her evidence, that did not mean they were required to take that doubt into account in evaluating the remainder of her evidence, particularly as to the offending conduct. They were free to do so, of course. The jury could decide for themselves whether evidence is incredible or implausible. They need not accept the evidence in order to convict. I'm being asked for purposes of this application to arrive at a view as to the prospects that the verdict will be viewed as unsafe and unsatisfactory. I should be very cautious in substituting my own view for that of a jury as to what lies credibly within the realm of human experience. None of the matters raised by the application, taken alone or compendiously, in my view, required the jury to reject the complainant's evidence of the charged conduct or have a doubt about the applicant's guilt. The matters largely involved contestable interpretations of evidence in several instances of a relatively minor or peripheral nature. The jury was not required to believe the complainant or rely on her evidence where inconsistencies, implausibilities or inaccuracies or improbabilities were concerned. They were not required to do so, but they were not foreclosed from doing so, such as to have required it to doubt the credibility or reliability of her evidence of the charged conduct. Additionally, that part of the evaluation of a witness's reliability and credibility which is based on the manner in which the witness gives her evidence is a matter for the jury. That assessment is within the province of the jury as representative of the community, and they perform that function with a particular advantage of being able to unanimously agree after the benefit of sharing their subjective assessment of the witness. In Nona and the Queen, number 3, 2012, Australian Capital Territory Court of Appeal 60, Justice Ralph of the Court of Appeal of the Capital Territory, upon an application for stay of the sentencing proceedings, in referring the application to a bench of 3 justices, wrote that it is undesirable that criminal proceedings be fragmented, an approach of long standing. His Honour also referred to the Queen and Demarchi, a decision of the full Court of the Victorian Supreme Court, 1983, 1 Victorian Report 619, where the Court held that it is an unusual circumstance that appeal against conviction be heard before sentence has been imposed. I appreciate those are different circumstances in this application, but they confirm the exceptional nature and undesirability of such fragmentation. This policy was again referred to in Tonari and the Queen, 237, Australian Criminal Reports 490 at 493. It was said that the ordinary and appropriate course is to avoid fragmentation of the criminal trial and the appellate process. See also Wilson and the Queen, 2016, ACTCA 56, where Justice Revshogi at paragraph 13 recites in the context of an application for a stay pending appeal that, quote, to interfere with the ordinary process of the criminal law where sentence ordinarily follows from a finding of guilt is to fragment these processes, which is highly undesirable. This is not, His Honour noted, a situation where, as in the Queen and Samani 2016 ACTCA 48, the grant of a stay is necessary to preserve the subject matter of the litigation. In Wilson, His Honour noted, paragraph 29, that it would be in the rarest of circumstances that it would be possible to make a realistic assessment of the prospects of success of a ground that the verdicts were unsafe and unsatisfactory. This reluctance and rarity is highlighted in the judgment of Justice Brennan in the application of bail by Chamberlain pending her High Court appeal. His Honour then said, to suspend the sentence before an appeal is heard is to invest the verdict of the jury with a provisional quality, as though it should take effect only after channels of appeal have been exhausted. But the jury is the tribunal constituted to determine whether an accused should be convicted or acquitted, and its verdict takes effect immediately." End quote. Justice of Appeal Keane, as he then was, in Cook Construction and Stork Food Systems, 2008, 2 Queensland Reports, 453 at 455, said, quote, "Generally speaking, courts should not be disposed to delay the enforcement of court orders." A stay sought in this application is in effect an application to suspend the effect of the verdict. The application here is made on the basis that the stay would be accompanied by an order that bail be granted upon application by the Supreme Court to prosecute the appeal. Justice Brennan continued in Chamberlain, quote, "To grant bail in such a case is to whittle away the finality of the jury's finding and to treat the verdict merely as a step in the process of appeal. The central feature in the administration of criminal justice is the jury, and it is a mistake to regard the effect of its verdict as contingent upon confirmation by an appellant court." This was the third reason why Justice Croucher in Gant and Sadiq thought that trial judges should be reluctant to offer a view as to whether a guilty verdict is unsafe. The first was that once there is a case to answer, it is a matter for the jury, not the trial judge, to determine whether the accused is guilty or not guilty. The second reason is that once a verdict had been delivered, it is for the Court of Appeal, he said, not the trial judge, to determine whether that verdict is unsafe if it is challenged. In relation to Section 309, His Honour Justice Croucher expressed agreement with the view that only in very rare and exceptional cases would it be in the interests of justice to order a stay of sentence. Were it otherwise, there might be a flood of unmeritorious applications following sentencing by trial judges. This would undermine the respect which jury verdicts command in our system of justice. His Honour was confronted in Gant with very particular circumstances which led him to form a view that it was not open to a properly instructed jury to exclude the reasonable possibility that the paintings the subject of the charges were not fakes. If that was right, verdicts of not guilty had to follow. That is an entirely different, unique and distinguishable case than the matter of Mr. Carr's convictions. His Honour could not see how it was possible, as he expressed it, to rationally exclude the hypothesis consistent with innocence. This was a compelling argument that the verdicts were unsafe. The trial of Carr was not premised on competing hypotheses. I have no reason to form a view that the properly instructed jury could not reach a unanimous verdict, which it did. Justice Croucher at 211 noted that the power conferred by Section 309 should be exercised in very rare and exceptional cases. He added, "I expect it would be extremely uncommon that a judge might form a strong view, as I have in this case, about the safety of the verdict. Even rarer, says His Honour, will be the case in which, fixed with such a view, it is appropriate to exercise the power under Section 309, subsection 2. For it may still be the case that the respect that should be paid to a jury's verdict would outweigh other considerations." In his case, His Honour was also concerned about the effect of sending a person, quote, "a depressed 68-year-old man of unblemished character who is suicidal at the thought when a view of the evidence he should not have been found guilty of the offences charged. The second consideration adds its own weight to the view formed by His Honour as to what it was he should do, that is, stay the sentence he had imposed. The situation, in my view, here is different. The defence relied on Mr. Carr's mental health to bolster the argument as to the stay. I've expressed in the sentence the concerns that I have, which are reasonably based on the mental health aspects of Mr. Carr, coupled with the kind of detention to which he is currently subject in terms of the sentence. That is not enhanced by any view I may have about the verdict, and I do not consider that aspect either alone or in combination with the matters raised by the defence in argument as reaching the level of exceptional or rare. A couple of other references are apt in this matter. In United States of Mexico in Cabal, 2002, 209 Commonwealth Law Reports 165, an extradition case where the High Court discussed the grant of bail in a criminal extradition case, where the High Court observed at paragraph 39 that it is, quote, a serious interference with due administration of criminal justice to stay or order for imprisonment before deciding an appeal. The Court cited with approval the remarks of Justice Thomas in Ex parte Ma 1986, 1 Queensland Report 303 at 310, related to making the conviction appear contingent until confirmed. It places the Court in the invidious position of having to return to prison a person whose circumstances may have dramatically changed while at liberty or bail. It encourages unmeritorious appeals and undermines respect for the judicial system by the public spectacle of the recently sentenced man walking free and the public interest in having convicted persons serve their sentences as soon as practicable. Similar observations were made in Wooldridge and Asic 215, Federal Court of Appeal 349, and Kazal and Thunder Studios 217, 2017, Federal Court of Australia 238. In the Court of Appeal of New South Wales, in Obeid and the Queen, number 2, 2016, New South Wales Court of Criminal Appeal 321, at paragraph 17, an application for release on bail pending appeal, the Court stated, quote, it is inappropriate for the Court to say much about the applicant's prospects of success on appeal when determining a bail release application pending the hearing of such an appeal. The argument before this Court on such an application can never be as fully developed as it might be. Secondly, and consequently, this Court is confined to reaching only a broad overall view of the applicant's apparent prospects. In Garay and the Queen, 2021, Australian Capital Territory Court of Appeal 30, Justice Alcam discussed an application for a stay on sentence before sentence. On appeal to the Supreme Court of the ACT, Chief Justice McCallum, at 2022, 366 Federal Law Reports 307, noted at paragraph 21 that His Honour was not persuaded that the prospects of success on the appeal were so strong as to satisfy the test for obtaining a stay pending an appeal against conviction prior to sentence. Her Honour observed that having reached that conclusion, Justice Elkame was not required to expose his reasons in any great detail, as to a stay application is not a rehearsal for the substantive appeal. I respectfully agree with that statement as it applies to my decision. While not discussing in any sense the arguments raised before me as unarguable, I am not prepared to conclude any likelihood of their success as part of my consideration of the interests of justice. This was a case in which the jury heard all relevant evidence, in which the complainant gave evidence over about 6 days in total. The cross-examination was comprehensive in relation to each asserted inconsistency, incongruity, improbability and lie. There was no doubt that the complainant's credibility was not just called in issue, but presented and analysed as the only practical issue for the jury to decide. Each of these weaknesses were thoroughly explored. The jury were directed as to the law without demur or exceptions and deliberated for some 2 days with one only question about what to do in case of an inability to reach a unanimous verdict. In Barden Clay 2016 258 Commonwealth Law Reports 308, the High Court, in the context of a jury fundamental role as to the constitutional tribunal for deciding issues of fact, stated the boundaries of reasonableness within which the jury's function is to be performed should not be narrowed in a hard and fast way by the considerations expressed in the passages for the reasons of the Court of Appeal explaining its disposition of the appeal. To that I would with great respect add the considerations expressed by a trial judge in response to an application such as this, and also in the rhetorical fervour of the advocate in submissions. The assessment of the credibility and reliability of the complainant based on the content and manner in which she gave evidence is a matter for the jury. Matters which were put to the jury as, quote, highly improbable, or solid obstacles to conviction, or implausible and deficient, may well have not led the jury to the conclusion that it was not open to them to be satisfied beyond reasonable doubt of the applicant's guilt. It is not possible to know what path of reasoning the jury may have engaged in. They may well have reasoned that despite the difficulties in her evidence, she remained unshaken in her core allegations, rejecting aspects of her evidence while accepting critical elements. There is nothing, in my view, in the arguments about the uncharged acts, the evidence of Grant, for example, the evidence of Gucciardo and Keogh, which must have deviated the jury from this view, or added to her account of the charged acts. And much can similarly be said as to the vast majority of the other arguments submitted as foundational for the stay. Most had nothing to do with proof of the allegations against the applicant. Conflict between the complainant and other witnesses having become a major credit issue was for the jury to assess, in the light of the whole of the evidence, who was to be believed and why. There was nothing about the set of issues raised which was beyond the jury's competence to decide for themselves. The relationship between a victim and an offender is often very complex, and a victim may behave in ways which seem inexplicable. This too was a matter well within the capacity of the jury to determine, and they were not bound to conclude that any of her conduct affected her credibility. The jury were entitled to accept her responses as truthful. As presently advised, I am not persuaded that in the combination between the physical state of health and mental health of Mr. Carr and the arguments presented ably by the defence, that I should order a stay in the interests of justice. The application is refused.